To be a valid will, it must be done by a person who is of sound mind and body, meaning that they understand the decisions that they're making as they create the will, as they write the will, as they execute, meaning the time that they sign the will, they need to understand the contents of the will that they have created. It can only be created by someone who is 18 years and older in Washington state. A will also needs to be witnessed by two witnesses who are not beneficiaries of the will. And typically in Washington state, we also have a will notarized. It's the best course of action. In Washington, attorneys often use a document called a self-authenticating certificate to have their witnesses and their notary sign alongside the will to explain that all of the procedure has been followed properly for the will to be honored. Naming an executor in your will is a very important decision, and it takes some consideration. You want to name someone who is going to be up for the job. It's a job. It takes some time and effort to process a loved one's will after they have passed on. It's a lot like being a project manager. Oftentimes for married couples, they choose each other to act as executor, but it's also important to have a backup because things happen. Someone might not be able physically or mentally to handle the job. They might be experiencing too much grief. A disability might have happened since the time that you entered into the will. It's also important to choose someone who you really trust. This is an important job. It means entrusting someone with the distribution of all of your savings, everything you've worked hard to build over the course of your life, and making sure it gets to the people you intended it to and that your wishes are carried out. When considering who to be a beneficiary in your will, there's a few things that you want to think about. Now, for people who are married, it's often an easy choice to say, first, everything should go to my spouse upon my passing if they outlive me. And then next, if you have children, people often say everything to the children in equal shares. That's a pretty simple scenario, but for many people, things get a little bit more complicated. If you have one child who perhaps has more wealth, or you have one child who has a disability or is in a bad marriage and you're worried about the inheritance being subject to divorce or disputes or a substance abuse problem. There are a number of decisions to think about, and it really helps to talk to an experienced estate planning attorney who deals with this every day, because they're going to be able to not just give you legal advice, but also to help you with the practical considerations that go into a will. In Washington state, you can elect to name people that you would like to be the guardians of your children in your will. Now, you can name guardians if you have minor children at the time of your death, or if you are the guardian of a disabled child, for example. Now, the court still has to make a final determination when it comes to deciding who is going to be the guardian for your children or guardians. But your wishes are typically going to be honored absent some new compelling fact that would cause a court to be concerned about the ability or the safety of your nominated guardian to do the job of caring for your children and ensuring that their best interests are met. Determining who to choose to be the guardian of your minor children when you create your will and your estate plan is a really big decision, one of the biggest ones that you're going to make. So there are a number of factors to think about, and I advise talking to an experienced estate planning attorney who can give you advice not just on the legal aspects of nominating a guardian, but also talk through the practical aspects. Values to consider are, does the person I'm thinking about, one, have the interest in being the guardians for my children? It's a good idea to talk to who you want to consider and make sure they're up for the job and that they have willingness to do it. The other thing to think about is, do I share the same values when it comes to parenting and children with the people that I'm thinking about to be the guardians for my children? Things that are less important are finances, because there are other things that you can do to protect the financial resources that you've earned that you want to be passed on to your children or to be used to care for them. Things like having appropriate amounts of insurance, nominating a trustee to be in charge of the financial aspects of providing for your children if something happens to you, are all aspects of making this decision, which is so important and can be guided by working with an experienced estate planning attorney. Key components of a valid will are very important to execute properly, because if you don't do it right, it's not going to be honored by the court, and you're going to leave your family with chaos and conflict if you don't get this will correct.